Hi, this is Dave Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So this lesson comes about through a client I represented a few years ago. Came to me, said he wanted to file a downward modification of child support. Okay. He says, I lost my job through no fault of my own, which is the first hurdle you have to jump over to satisfy a downward modification case. And he said, I work in the restaurant field, and my restaurant went belly up. Okay, well, great. So we filed a petition. I also had a discussion with him, and I said, look, the legal standard is you have to prove to the court, A, you lost your job through no fault of your own, B, you kept a diligent job search. And what that means is you are able to document to the court that you are out looking for a new job that is, quote unquote, commensurate with prior earnings, skills, education, etc. And that you're essentially spending 40 hours a week in your job efforts. So usually if you file your petition, you get to a hearing several months later, you are going to be able to document to the court hundreds of job efforts. And if you want to contend to the court, well, I lost my job in the restaurant field because the restaurant field in New York City sucks right now. Well, guess what? You have to expand your job search. You can't just look for jobs in other restaurants and then say to the court, well, gee, yeah, no restaurant is hiring, so I want a reduction of my child support. Give it to me. Don't count on the magistrate actually giving it to you. Instead, say, gee, if the restaurant field sucks, maybe I need to do something else for a living and apply for other jobs in other fields that would at least somewhat be commensurate with your work skills and your education, etc. So my advice to that client was, make sure, if you were previously earning close to six figures, look for any job that you can find that would pay even in that ballpark, because that is going to be the standard at trial. And so that is the big takeaway. Do not merely think, if you are looking to reduce your child support, that all you have to do is say, well, I lost my last job. That's it. No, you have to keep that diligent job search. You have to be able to document it to the court at trial. And if you fail in both of those issues, lost your job through no fault of your own, documenting your job search, you are going to lose your trial. And then the problem is if the other side, and it's usually the mother, not always, but if the mother comes in, files a violation case in conjunction with your modification case, guess what's going to happen? If you lose your downward modification case and the mother wins her violation case, she's going to get reimbursed counsel fees in all likelihood. So those are the risks you really take. So you need to meet with your attorney as soon as possible after you lose your job so that you understand what you need to prove to win your case. If you're looking for more answers like this to similar questions, definitely check out my blog. You'll find it at blivenlaw.net/blog. See you next time.